Hello, everyone. My name is Fredrik Jorgensen, and by my side here I have Katinka Svanberg, expert of public international law. And today we're going to talk about, in a course we could call it 101 in public international law, about the basics of public international law. And I'm going to be asking the questions, and Katinka is going to be answering them.
Thank you, Fredrik.
Welcome. So, what is international public law?
Public international law is an area of international law that covers the obligations of states and international organizations, but not private entities or private individuals. They could only be bound through their state. That's why it's called public international law. So it's a part of international law.
And how do international law, public international law, how does it differ from domestic law?
Yeah, it differs in different respects. I think three basic different respects. One is that they do not have a mandatory sanction system. Like in a state, the government has a police force and it has courts to help out. And if you commit a crime, the police will catch you, hopefully at least, and then you will have a trial. And if you are convicted, you will go to jail. But there's no mandatory, there's no international court with a mandatory jurisdiction in public international law, and there's no world police.
No world police?
Could be ordered about.
No formal world police?
No.
Right.
But basically, it's a presumption that it's based on the will of a state to commit to public international law. But of course, you're right, when the norms are there and the state has accepted them, then they are bound by those norms.
Yes. Right. What are the sources of public international law?
There are about 4 sources of public international law. Sometimes you would say there are 5 if you mention jus cogens. The first one is treaties, international conventions. We find the sources in Article 38 in the International Statute of the International Court of Justice. You can look it up. In Article 38, 1A, international conventions, that are international treaties. That's international agreements made by states in writing, which creates obligations and rights, like a legal contract. Those are that's a primary source of public international law. Second, but the same ranking as a primary source is customary international law. That's unwritten rules, like customs, based on practice. The practice states can create customary international law by their behavior. A practice that they act in a certain way in a number of instances. They have the same practice carried out in the same way, but it has to be with legal intent. It's not something that just happens, but they have a legal intent to carry out this practice that will create customary international legal norms.
Right. What are treaties?
Treaties I mentioned, that's like international conventions. Treaties, those are like a contract. It's an international obligation in writing, creating obligations and rights in a document in writing.
So a treaty is like a contract, but more like treaties is reserved for like contracts between states. Treaties
or
between
international organizations and states, or as between 2 international organizations, because the international IOs, they are made up of states, while a non-governmental organization, an NGO, are made up of individuals.
Right.
And then they are outside public international law, because public international law are concerned with the behavior of states.
Right.
They are the legal subjects of public international law, and international organizations are another legal subject of public international law, while individuals and NGOs, they are just a secondary subject of public international law. Why? Because they cannot create obligations and rights in public international law. Public international law is only created by states or international organizations made up by states.
What are principles of law recognized by civilized nations?
Yeah, international legal principles are such that you can find in any domestic legal system. Could you think about any such principles?
Sure. Pacta sunt servanda is one, and like contracts shall be kept. That's one.
Yeah, that's an important one. Also, nullak poene sine lege,
no punishment
without law.
And no crimen sine lege, no crime without law.
Yeah.
Same thing, basically.
Against retroactive criminal jurisdiction. Those are very important principles, and those are also part of the sources of international law. All those old Roman law legal principles that you can find in any domestic legal system. Those were the three primary sources. Now we move on to the secondary sources of international law in Article D, in Article 30. I mean in paragraph D in Article 38.
Right. Yes. What are the secondary sources of public international law?
It's those famous publicists and professors in international law, the legal writings. That is doctrine, the doctrine. And then it's also case law from recognized international courts.
Right. And how does the primary and secondary sources interact? How do they interact?
They interact in the way that you can hear. The primary sources are the sources where you find the legal norms that the states have kind of accepted. And the secondary sources is where you find evidence of the primary sources. The secondary sources can never make law, but they can tell you the content of the existing law.
So
you will usually, as a student, turn to your your textbooks to find the content of, for example, customary international law. The evidence of what is at a certain date customary international law in a certain instance. Or you can also look it up in case law where it's pronounced.
But how are the sources ranked, and what do we do if they collide with each other?
Yeah, if they collide with each other, that's a good question. Yeah. Then you have some ways of interpretation. And the first norm of interpretation is lex, the latest one, the most recent law or norm is the one you will look for.
Lex posteriori?
Lex posteriori.
Oh, that's another legal principle.
Yeah, it's another legal principle.
There you go.
There you go. So, so if you have a treaty and because all the primary sources are equal, but if you have a treaty that collides with customary international legal norm, then the most recent one will prevail.
Where and how do I find international legal norms?
No, sorry, we have another rule of interpretation.
What's that?
And that is also in a collision case.
Okay.
And that is also lex specialis.
Yes.
The most special, if the treaty is more detailed, for example, than a customary international legal norm. And that is most often the case, that the treaty is more detailed with all its provisions, while customary international law is more broad and sweeping. Then the more special norm will prevail over the more generic rule.
Exactly. So where does one find the international legal norms, like in the library, online, or and where are they codified?
Yeah, they're codified. Usually each state will give out a publication with the treaties the state has become party to. And you can find those in your national
like State
Foreign
Department?
Office, State Department.
State
The
Department.
State Department.
The U.S. is called State Department.
Yeah, the U.S. State
Department of
Department
State.
will have all the treaties that the U.S. has signed and become party to. And then you can also find the UN conventions. That's usually lawmaking treaties. Treaties that codifies different legal areas in public international law. Those you can find in the UN collection on treaties, UNTS it's called, and it's online. And also the State Department, you will find the US treaties that US has signed online.
Are all states obliged to show publicly the treaties that they have entered into?
No, but a democracy would show that.
In a democracy, you would show. So
Yeah,
that means that in a democratic state, most or all international treaties would be public.
Yeah, they would be public, because also in a democracy you would have usually some treaties are self-executing. That means that when an authorized person from the government has signed the treaty, it will start immediately to work for that state, and it becomes party immediately. While many states also have the form of ratification. That means you have to have a parliamentary acceptance also.
Yes, like two step. Yeah.
The signing, and then the second step is the parliamentary acceptance.
But in the U.S., there was some exclusions to that rule, and if the president signs a treaty, international treaty,
Yeah, it could be self-executing.
legally binding for the U.S.
Yeah, but you also have many instances of ratification as well by the Congress.
What is the law of treaties?
The law of treaties is the law of contracts for treaties. If a treaty, that's a contract as between states.
Yes.
While law of contracts is, of course, the law on contracts between individuals. But it's the same type of rules about the contract or the treaty, how you enter into a treaty, how a treaty ends, fraud, etc. Those type of things that can happen in a treaty, the pacta sunt servanda rule. It's the rules that governing treaties.
All right. Finally, what is soft law?
Oh, soft law. Here we show the pyramid, the sources of law. We can draw them as a pyramid shown here. And we have covered the four most usual sources of law that are set out in the ICJ statute, Article 38. We have already covered them. Treaties, customary international law, and then principles of international law, the primary sources, and then the secondary sources, that was the doctrine. Writings of famous publicists in international law and case law. But then at the top of the pyramid, look here, it's a small top of the pyramid where I have put in jus cogens. That's Latin for peremptory norms of international law. And a peremptory norm is a norm that can never be broken. And they are mandatory. That's the difference. They don't build on, the state do not have to accept to be bound by a jus cogens norm to be bound.
And the jus cogens norms were, as I recall, was it prohibition against slavery and genocide and international piracy?
Yeah, and maritime piracy.
Or any piracy. There can be, I think, maybe piracy on land, I guess.
No, but no, it's
only
maritime.
Only maritime piracy.
Yeah.
Okay.
And then you had the prohibition against poisonous gas and bacteriological warfare.
Plus apartheid-like systems.
Exactly.
Racial discrimination.
Yeah, racial discrimination as well. So there are, and the prohibition against torture.
Torture also.
But why so few norms qualify as use organs is that although they are peremptory, they build on the fiction that they are accepted by most civilized nations in the world.
Well, they in fact are not, but they have to be bound by them anyway.
Yeah.
And then upon this follows the principle of global jurisdiction.
Yeah.
What does that mean?
Yeah, that's the universal jurisdiction connected to the jus cogens, and there is also erga omnes norms. A jus cogens norm is also said to be erga omnes, that is binding for all. It's how, and that means that also if it's binding for all states have jurisdiction over a break of a jus cogens norm, and that is the universal jurisdiction case.
Yes.
Universal jurisdiction means that if someone has committed genocide, for example, it can be indicted.
Indicted in any country.
In any country. But then, of course, you also have to have rules in your national law that controls when someone, for example, in Sweden or the US can be indicted. And that is, for example, in Sweden, you have to be on the territory or to be a citizen of Sweden to be indicted or be in Sweden. But in the US, you can also take someone from another country, being a citizen in another country. You have extraterritorial, a wide extraterritorial jurisdiction in your in your domestic system. That's more unusual. Yeah. But then you can try anyone who has committed a jus cogens crime theoretically in the US.
Right, but that goes for most civilized countries, that they can indict someone, and not all countries have the freedom to
ask for extradition.
They can ask for extradition.
Yes.
But then also extradite themselves is also that.
Yeah,
also
but strong states like the US can also then take someone.
Just grab someone,
but built on your national laws. That's a US crime that was done.
Exactly.
And that has happened, for example, with some Egyptians who were in Sweden, but they were
they were
suspected of terrorism. And then they were taken at the Arlanda Swedish airport to the US for trial in the US.
All right, Katinka. Anything you would like to add before we round up this this podcast here?
No, I think now we have covered most of the things. We must take with us that public international law differs in certain respects from domestic legal systems. And it builds on the states as primary subjects of international law and international organizations made up of states. And we also take with us, we have covered the sources of international law.
The 4 or even 5 of them?
5, yeah. If we start in the pyramid, the top was a kind of very strong customary international law. That's jus cogens.
Yes.
It's a kind of unwritten legal rules, about 10 or so of them that you can never break. And they're peremptory. And then we had the treaties. Those are the most easy to apply because you find them easily. The text of them is if a state is a party to them. And then you had customary international law, and that's unwritten legal rules, but the same standing as treaties. And then you had international legal principles, and they are usually a court would use them in the interpretation of the other norms. But they are also primary sources. And then you had the secondary sources, the doctrine and case law. And then we also covered universal jurisdiction. We won't repeat what that was.
Erga omnes also.
And erga omnes, and also how international law, public international law, is different from domestic law. And we will also just mention that public international law is part of international law. Sometimes we just say, I'm a professor of international law. But public international law is a little bit more narrow than international law.
Yeah. So international law is, there's other law. It's more commercial law. Not public subjects are, it's wider than just the binding treaties of public subjects, legal subjects. Like states and organizations.
Exactly. It's international private law. That's also when you travel abroad and something happens with insurance, for example. All those things that could happen an individual when traveling, or companies, multinational companies being in different countries. That's international law, but it's not public international.
No.
Thank
All
you.
right. Thank you, Katinka. And great to have you here on a podcast. And if you have any questions, you're free to ask Katinka in her class lectures or online.
Thank you, Fredrik. And you have your law firm, Rättsakuten in Swedish, with those characteristic, A with 2 dots.
A with 2 dots, that's Ä in Swedish. And that's a legal emergency law firm. Most people who have they have a pressing need for something when they need a lawyer. So that's why I called it an emergency law firm.
Yeah.
Because people are in a hurry to get things done.
Yeah.
So that's why I call it. And we help people out when they have a pressing and urgent need to get things done.
Yeah.
Oh yeah.
Thank you so much.
Thank you very much, everyone.
Bye-bye.